Good morning, everyone. This is George Tran, just giving you an update of what's happening, what I'm doing, what my civil action is, and all that good stuff. So, as you know from my previous post, I have received a notice of removal to federal court, and I've already entered my objection to it. But I wanted to kind of show you the legal um, outline of what's going on and telling you what I'm doing right now to keep you up to date. Okay, so firstly, let's look at this. The lawyers for Wachovia is claiming to remove the case under Title 28 USC Chapter Point 1452, and they are correct. They actually can remove any claim into bankruptcy court because if there's a civil action and if it relates, then it can move into bankruptcy court. So they will get that move into bankruptcy court. They also quote Federal Bankruptcy Code rule number 9027, which is notice of removal. You can remove the action into bankruptcy court. Any party can do it. You can move it into bankruptcy court, so that's fine. The other thing about bankruptcy court is the federal rules of civil procedures apply, and the federal rules of civil of evidence apply. So here's so they are in the right of moving the action from circuit court into federal court. Now, the thing is, the timeline for the civil action still apply. So what does that mean? Let me go into the timing. They can only move the action if it's within 30 days of a initiated before the commencement of the case. The case in this case meaning the federal case. So they can do this if it's an order can be terminated. Anyway, within 90 days, they can definitely move the action before the commencement of the bankruptcy case. And it is true, they have the right to move the case. Okay, so what I want to bring to your attention is this thing, procedure after removal. This is really, really important. Where is it? Applicability of this part. Okay, so why this is important is the timeline. Okay, the applicability of this court repleting is not necessary in a removed action in which the defendant has not answered, and thus far they have not answered. The defendant shall answer or present other defenses objections available under this within 21 days of receipt of service or otherwise copy of the initial pleading set forth in the claim. Okay, the initial pleading, they have to do this within 21 days of the initial, i.e. the circuit court action, within 21 days, or within 21 days following service of summons of the initial pleading, or within 5 days following the filing of the notice of removal, whichever period is longest. So this is really important. Okay, in other words, the longest period is it's been way over. Actually, it hasn't been. It's been August 25th is the date of the initial filing commencement, and so they have removed it on Friday. What was it? Just the 24th, I believe. Yeah, they removed it on the 24th. Now, so they have 5 days following the filing of the removal to enter a answer. Okay, so they have 5 days before I can. Otherwise, if they don't answer, then I can enter in a order for default judgment. So that's one thing. So the other thing I want to bring to your attention is the time, application of time. Let me show you. Calculation of time is really important in here. It says, I might have a hard time finding it, but it says that the calculation of time, is it here? The calculation of time in federal rules of bankruptcy court includes weekends. Okay, includes weekends. That's really important in calculating time. So it was Friday when they served me the removal notice. Okay, when they filed the removal notice and served me the removal notice, I received it on Friday the 24th. So today is the 27th, and so add 5 days is on the 30th. if they have not entered an answer, then they are in default. So what do you do in a default? Let's go into Federal Rules of Civil Procedure, entering a default by the court. Now, if a party against whom a default judgment is sought has appeared, that party or its representative must be served with written notice of the application at least 7 days before the hearing. So they have entered a desire to appear, and so I have to notice them. It says must be served with written notice. Okay, so I have to notice them and give them 7 days that I will be entering a default judgment. So today I will be faxing to them my intention to file for a default judgment. Okay, so that therefore I have noticed them and give them 7 days. So come next Monday, if they have not entered a default an answer, then I am entitled, because under the Federal Rules of Civil Procedure, under the Bankruptcy Code, under the removal, okay, they have 5 days. Okay, 5 days, and then I have to notice them and give them 7 days. So by this time on next week, then they will be in default, and I will be filing for a notice of default. So now, given that they are entitled to move and remove this action into federal court, I have something up my sleeve that I filed will file with the court today, and it has to do with the Federal Rules of Evidence. The Federal Rules of Evidence requires the original, okay, to prove blah blah blah, and the admissibility of duplicates. Okay, and here's the important bit, number 2. In circumstances, it would be unfair to admit the duplicate in lieu of the original. So in other words, it is not admissible if it's unfair to admit the duplicate in lieu of the original, because what is in the duplicate, in the original, that is not present in the duplicate is a chain of title of assignment, which the copy made years ago does not have. So this rule of evidence does apply. So another really cool thing about bankruptcy court, which I want to show you, is this. It's really, really cool. This is my, what do you call it? Memorandum of law. Okay, so in the memorandum of law has this really cool thing that I want to share with you. Okay, and this is under the Federal Rules of Bankruptcy, Rule 3001D. Here is a really, really amazing piece of law available to debtors. Okay, Rule 3001D says evidence of perfection of security interest. If a security interest in property, i.e. real estate is property, of a debtor is claimed, the proof of claim shall be accompanied by evidence that the security interest has been perfected. This is really important. Security interest has been perfected without a doubt. It has to be perfected, meaning it's true and true. Okay, so then I go on to say that under UCC Code 501 says upon demand they have to exhibit the instrument. Okay, and then I quote the rules of Federal Rules of Evidence, admissibility of duplicates. So they have to provide the original. A photocopy cannot be admitted. The original provides a critical piece of evidence having only valid and legally binding chain of title of assignment of the negotiable instrument, identifying the last legal holder in due course. A photocopy made years ago is insufficient proof of claim and is rejected by the plaintiff as it does not provide any evidence of who the current holder in due course is. All right. So here, the thing I want you to understand how important this move is. This move, using this very critical rule here of 3001D, says that the burden. Now, let me go back and remind you, the burden of proof is on the plaintiff in a civil action. However, when in bankruptcy, that changes. In bankruptcy, because of this rule here, the party seeking to if security instrument of the debtor is claimed by the creditor, the creditor must provide proof of claim by evidence of security interest to be perfected, okay, that has been perfected. So what that means is the burden of proof all of a sudden have shift from the plaintiff to the creditor. Now they have to provide evidence that they are entitled to enforce and have perfected security interest in the property before they can claim. So this is really important, and I encourage you to use this. But anyway, so as of today, I'm filing to the court a notice of intent to declare, file for a motion for default judgment, as I'm entitled to, and in 7 days I will do so. I'm also filing this memorandum of law in support of my arguments for this case here. Basically, the plaintiff submits this second memorandum in support of the declaratory judgment and motions this court to take mandatory judicial notice of the following. At issue is who is the holder and the defendant whether the defendant has the authority of or from the holder. Under bankruptcy court, the party claiming to be a secured creditor must provide evidence of perfected security interest. Therefore, the defendant has the burden of proof in this action, and this is really, really important. They have the burden of proof. I hope this has been informative and educational. This is George Tran signing out.